Ladies and gentlemen, as the late David Frost used to say, for those of you who can remember him, hello, good evening, and welcome. My name is Graham Wood. I'm a director at Europa Law. I appreciate your coming this evening and showing your support. For those of you unfamiliar with Europa Law, we provide programs, information, and know-how in contract, commercial, and cross-border law and practice. I apologise in advance to any Brexiteers in the audience. However, as our name suggests, we particularly acknowledge the invaluable contribution made by EU law to the corpus of law in the United Kingdom over the last 40 years. Indeed, so valuable has been that contribution, we're told the government wants to retain all of it through the medium of a great reform bill, which raises the prospect of what a former Lord Chief Justice has described as a tsunami of legislation. At Europa Law, we also recognise the unparalleled expertise which the Court of Justice in Luxembourg brings to the interpretation of EU laws, and its future status in a post-Brexit UK is a matter of some debate and speculation. And we shall have to see what emerges from the strong and stable leadership which we're assured will be brought to the Brexit negotiation table. I must just say a few words of thanks, firstly to our esteemed panel who are here. You'll see them shortly. Thanks to them for giving their time to join us this evening. I appreciate that Natalie Leven QC has been able to join us at short notice, and that Dominic Grieve has sacrificed the evening of his birthday to be with us. I was going to suggest that we all join in singing happy birthday to him, but I think he would rather we didn't, so we won't. And to Lords Clark, Phillips and Faulkner, many thanks for your willingness to be part of a public event. I must also say a special word for our moderator, Majid Nawaz. Majid, as some of you may be aware, is the founder of Quilliam, which does such invaluable work in the field of counter-extremism. And given the events in Manchester on Monday and the fallout for his organisation, we particularly appreciate his being here this evening. I taught Majid when he was an undergraduate some years ago, and I can attest to the fact that he has a finely tuned legal brain. Finally, I want to say how proud we are to support the work of the Stroke Association. Nothing is more vital to human existence than the integrity of the brain, and stroke is a direct attack on the brain. My mother was felled by a massive stroke, so I know firsthand the terrible consequences it can have for the victim. At which point, I would just like to introduce Catherine Ward from the Stroke Association, who'd just like to say a few brief words.
Hello, good evening everyone. My name is Catherine Warner and I work at the Stroke Association. I wanted to say thank you very much for everyone coming this evening. All of the proceeds from the ticket sales are going to be donated to the Stroke Association to help our work to conquer stroke. And I also want to say thank you very much to the very esteemed panel, and to Graham and Amona and to Pushkin as well for this evening. I also wanted to mention that we have a stand outside where people can get their blood pressure checked. Blood pressure is the biggest cause of stroke, and it's a very simple test to see whether you have high blood pressure or whether it's in the safe zone. So please come and say hello and get your blood pressure checked this evening. Thank you very much.
Well, without further ado, I'd like to introduce our moderator, host for the evening. He's the founder of Quilliam, fantastic organisation, as I say, great work. You may know him as a presenter also for LBC on the weekend shows. So could I ask, given his time at a difficult time for his organisation, Very warm welcome for Majid Nawaz.
Thank you, Graham. When the tragic events unfolded in Manchester yesterday, Graham and I were in contact to try and work out whether indeed this could continue. And Graham said that actually it was his strong view that in defiance of people that would like to disrupt our everyday lives and our activities, that this event indeed should continue, not least because it's in the aid of a charity, the Stroke Association. So I thank you all, first and foremost, for not changing your schedules and attending and not allowing yourselves to be cowed nor succumb to fear for those who would like to disrupt our living. Lords, ladies and gentlemen, welcome this evening. The topic for the debate, and I hope it's a lively debate, is the Supreme Court, a rather controversial title, Guardian of the Constitution or Enemy of the People. It falls upon me, the onerous task falls upon me to moderate this panel. Of course, Graham, in our law tutorials, designated me as the Court of Appeal in class because he felt that I was able to very quickly arbitrate between the fierce debates that would arise in our class. So he's asked me to return in that role as the arbitrator here today. But the topic won't be restricted to the controversial headline. Of course, that headline, most of you should know, arises from some of the headlines in the newspapers, in particular one newspaper that comes to mind after the decision made by the Supreme Court that the triggering of Article 50 does require a vote in Parliament because a referendum doesn't have the legal power to override parliamentary sovereignty. And so that's the title, but we are going to move to some other topics as well. I'll just give you a brief as to how this will unfold for the evening. The time now is 6:48. We'll take it until 7:45, hopefully, with about 10 minutes perhaps for some questions and answers. And then after that, Graham will guide us all to a reception, which should continue, I think, because we're slightly behind schedule. It was due to continue until 8:30, but I said perhaps your hospitality will extend an extra 15 minutes after that as well. So the reception should hopefully carry on until 8:45. And what I'll do is I'll call out the panelists one by one. If you could kindly take your seats from the left here, and then along the bench. There's a special chair at the end there. That's primarily because there wasn't enough room on the table, but we can pretend it's the special chair for the favourite, whoever ends up on that there as well. So let's begin, first of all, by introducing Justice of the Supreme Court, Lord Clark. Thank you. And former Lord Chancellor, First Secretary of State for Justice, Lord Falkland. Right. And our former Attorney General and Conservative candidate in this general election, Dominic Busey. Natalie Levin QC, human rights lawyer and who recently chaired the Justice Working Party on Judicial Diversity.
We're all pretty much ashamed about leaping up like little gazelles.
Natalie, would you mind coming in? Yes, please.
I was going to fall off.
I know you want the special chair, but
more glasses.
Now, I do remind Lord Phillips that there are some stairs here if you want them. Lord Phillips, past President of the Supreme Court. Now, thank you all. This is our panel, and I'm just going to very briefly mention the topics we're going to cover. I have some questions on the topics, and then we'll move of course, to the panel and then to the Q&A if we have time as well. Hopefully we will have time, I'll make sure of that. The first topic we wish to address is the topic of the title, Judicial Independence and Freedom of the Press. I'll have two questions on that. There are more questions, but I think for the sake of time, I'll stick to two questions on that. After that, we'll move to certain constitutional issues arising from the topic of the day constitutionally, and that is Brexit. So constitutional issues arising from Brexit. Of course, panel members can speak to their strengths on each of these. It's quite a strong panel as it is, so I imagine there will be plenty of strengths there on these issues. The third topic, the future relationship between the legal orders of the UK and the EU. That is the third topic. Then we'll move on two issues of diversity and the Supreme Court. I thank you, by the way, Graham, for ensuring there was some inclusive diversity represented on this panel. It's an important topic, and I think we'll have some questions on that. And then after that, we'll move to you all for your own questions as well. And if you have questions, I ask you to raise your hands. I'll select you, mention your name and your affiliation. The affiliation can be anything you choose to introduce yourself as, but very succinctly ask a question, please, and don't give a speech, because already, as you can see, we have a packed panel, and we don't have much time. And so speeches will be disqualified from now. That's my warning. Right, let us begin. So thank you all again. On the topic of judicial independence and freedom of the press, I hope you don't mind. I'm going to remain hovering above here, because there isn't really room there anyway, so I'll just be looking down and intimidating everyone to make sure they answer the questions. So on the first question, and that is on the topic of judicial independence and freedom of the press. It's interesting that during the Article 50 case, I should say, judicial vitriol was directed at none other than the Lord Chancellor, Liz Truss. And indeed, Lord Faulkner quoted, you are quoted as saying in the press, in reference to Liz Truss, and I'm going to read the whole quote and then get the panel's views on this, starting with you, Lord Faulkner. She has no respect either in the political or the legal world. Her survival depends on retaining the support of the Prime Minister, but her lack of understanding, coupled with a department which loathes her, means she can't deliver. The consequence of her only lifeline being the Prime Minister is that she could not be weaker as a defender of the judges and the rule of law. And that came about, correct me if I'm wrong, in response to the headlines describing the judges as enemies of the people, and the feeling that arose that Lord Chancellor Liz Truss didn't do enough to defend the judiciary from the attacks of the press. In Liz Truss's defence, she took a view that the freedom of the press was as important as the independence of the judiciary, and that she shouldn't intervene. And so that's my first question, really. Lord Faulkner, will begin with you. Is it not right that the press should be allowed to scrutinise any branch of government?
Yes, and I think it's right that the press are entitled to say what they think within the limits of the law about judges and about judges' decisions. My complaint about the Lord Chancellor is the judges will begin to become pressured if the state itself begins to support attacks on the judges. And my big complaint about Liz Truss is not that she was silent, but that she and the Prime Minister appeared almost to be siding with the press in thinking that the Divisional Court of the Queen's Bench Division, which had found against the government on the Brexit case, could properly be described as enemies of the people because they had found against the government in determining whether or not Parliament needed to approve the removal from the European Union. The rule of law and the independence of the judges is very, very ingrained in our society. It's never going to be discarded. But be under no illusions. If you can attack judges in the way that the President of the United States of America attacked the judges that held after a judicial hearing that his executive immigration orders were flawed legally, if you end up being abused like that, then although the judges will want to uphold judicial independence, the idea that that is not going to affect the body of judges over time is absolute nonsense. That is why it's so important that the state makes clear that the judges have complete freedom to come to the decisions that they want. The press can attack them if they want, but the state has got to back their ability to make those decisions.
Thank you, Lord Faulkner. Now, Dominic Grieve, this is your government, this is your party. How do you respond?
Well, I think I made pretty clear at the time that I disagreed with the failure of the Lord Chancellor to speak out on behalf of the Divisional Court and the judiciary. The government, the interesting issue was that the government was a party to this litigation. So it wasn't as if it was just any old litigation. And therefore what the government needed to do was to disassociate itself from the attacks that were being launched at the judges who had come to the decision, and just make clear that whilst they might disagree with the decision because they'd argued against it, they completely respected the judiciary's independence and their right to make the decision they did, and they would simply follow ordinary practice in appealing it to the Supreme Court if they wanted to do so. And unfortunately, the Lord Chancellor didn't do that. It may have been inexperience, because she'd been recently in office, I don't know, but there was a silence which was not acceptable. And I have to say, the attack on the judges went way beyond the acceptable, because it wasn't just an attack on their decision, which is a perfectly legitimate thing to criticise if you want to, but it was an attack on their integrity, without a shred of evidence for backing it up. And my personal view was that the decision was not at all surprising, something which I'd been going on about. But even if the decision had been surprising, there was still no justification for attacking their integrity in having made it. And the Lord Chancellor is there, and the oath of office which the Lord Chancellor takes is there to uphold the rule of law and protect judicial independence. So it's very important that the Lord Chancellor should do that, particularly in an area or matter in which the government might appear to have an interest. So that's what I said at the time, and I have no reason to disagree or resile from that comment now. I don't think it's the, in one sense, the end of the world. Like so many storms, it's blown over, but I just hope very much that the lesson has been learnt now, that there is a duty on the Lord Chancellor to speak out in those circumstances. For reasons that I didn't quite understand at the time, there seemed to be some idea that by speaking out it was in some way attacking the freedom of the press, but it wasn't. So I think somebody was mistaken about that.
But is there not a more cynical reason behind it, and that it was for electoral purposes, and the Conservatives, the government, didn't want to alienate the population who voted for Brexit?
Well, I'm not, actually, funny enough, I'm not sure that that's the case. Clearly, it was a difficult time because in the aftermath of Brexit, there was a public surge, and there's no doubt it happened during the Miller case, where there were people believing that the decision of the people was going to be in some way undermined or thwarted. But in fact, as people subsequently saw, what the decision of both the Divisional Court and the Supreme Court eventually did was to identify the right constitutional route to be taken in order to resolve this issue, and the issue was resolved in a way that now it's ancient history, because Parliament voted to trigger Article 50. So it was clearly a very emotional time. There were people who had got it into their heads that they were going to be thwarted in what they had achieved in the referendum. But all the more reason for the government to pour oil on troubled waters, which is what they should have been doing. But I don't think it was necessarily electoral advantage. I think, if you really want my opinion, that some people just lost their head. But then there are ministers in government who are there to try to make sure that people don't lose their head. And that's why our constitution is framed in the way it is. So there was a minor constitutional failure, and I hope it doesn't happen again.
Natalie, I want to bring you in. Do you agree with Dominic Grieve's explanation, or do you think there was some cynical purpose behind it?
I rather doubt there was anything cynical. I'm not wholly convinced that this government is prepared to criticise the Daily Mail very strongly in public. I suspect it was more that than cynicism. I think it was unfortunate that Liz Truss was both, as Dominic said, a recent appointee, and I strongly suspect not well advised, because the point that struck me immediately is that she actually has a statutory duty as Lord Chancellor to uphold the rule of law, and I'm not even sure she was actually told that. And not being a lawyer, I'm not. I think some of these problems go back to the constitutional settlement when Lord Faulkner was in government, where the Lord Chancellor is now simply a career politician at a middle-ranking stage in her career. And that puts her in a very different position from the old type of Lord Chancellor. I have to say, with owning up straight away, I'm obviously here as the token woman. I'm obviously here with the diversity hat on. I do very much wonder whether if Liz Truss had been an elderly white male, he would have got quite the level of fury.
We're coming to that topic.
I know,
yes.
but it comes up here. I do remember David Blunkett used to routinely attack the judges. He did it, not the press doing it. He would do it when they found against him as Home Secretary. And I don't remember quite the same level of outrage that the Lord Chancellor or the Prime Minister of the day hadn't reined him in. So I don't quite share, and I also completely disagree with Lord Faulkner with the idea that these judges are going to be intimidated by hostile comment in the Daily Mail, and that that's going to change the ultimate balance of the Constitution. I've got to say, those aren't the judges I know. I suspect there was a good deal of water off a duck's back.
I think the Daily Mail was, I think if the President of the United States of America calls you a so-called judge or a Mexican, will you find against him? I think over time you will see judges behaving in a different way. The judges do not want to fall out with the state in a massive way. Not because they're toadies of the state, but because they see themselves as having an obligation to try to do that. And I think it's that interface that is problematic in a subtle way to the independent judiciary. It's not the Daily Mail, it's the state that really matters. That was the point I was making.
Thank you. Right. We will come back to the issue of diversity. Thank you for that, Natalie. But as I'm very happy because I see that disagreement is beginning to emerge, and I want to encourage everyone to disagree, because I think otherwise it makes for quite a bland conversation. Now, one of the stated objectives of the government in setting up the Supreme Court was to bring about greater transparency, interestingly enough. Are the justices of the Supreme Court not just as unknown to the public as their predecessor law lords were? I'll begin with you, Lord Clark, and then we'll go to Lord Phillips on this topic as well.
Well, I don't really quite understand what you mean by transparency. We've all had several years on the bench and done things of one kind or another. All that is free for anybody to see. We can see we're old and male. I can see that's a very bad thing. But I don't really quite understand what you mean by transparency. What have I got to be transparent about? The colour of my bathing costume, or?
Well, I imagine in this instance, hopefully it's not a transparent bathing costume. But I imagine in this instance the issue is about what the Daily Mail alleged in this case were the perceived prejudices, political prejudices behind the decisions. Any political allegiances that may have been there, and the legal reasoning, which I imagine is transparent because it's written out for everyone to read. I don't know if they read it, but I imagine that's what they led to. But in the case of the government's decision to set up the Supreme Court, I think it was more that the average man on the Clapham omnibus understands who the judiciary are. Are you more or less accessible now than you were before the Supreme Court?
I think we are more accessible now than they were when they were in the House of Lords. And the whole point of the Supreme Court, if it has one, is that it does, hopefully, satisfy the principle of the separation of powers between the legislature on the one hand and the judiciary on the other.
Yeah.
Which, although no problem had really arisen in all those years that they operated in the House of Lords, and there's no doubt that the Conservative Party would never have done the move, because they would have proceeded on the President Truman's dictum, if it ain't broke, don't fix it. Because it worked perfectly well and the conventions worked perfectly well. But I think the current situation is much more transparent in that respect than it ever was before.
Lord Phillips, it worked perfectly well, but it's much more transparent now. My amateur legal mind indicates a slight contradiction between those two things.
Thank you. You said a moment ago that the government set up the Supreme Court because of desirability of transparency. That doesn't accord with my recollection at all. It doesn't accord with my recollection that the government set up the Supreme Court. It was Tony Blair, without consultation with the government, who just...
There was an act of Parliament.
There was an act of Parliament, but the decision, the motivation behind it, was
Tony Blair?
Was Tony Blair's motivation.
He was the Prime Minister, surely, the government.
And I don't think he ever suggested that what he was concerned about was transparency. But I was concerned about transparency, and I thought that one of the powerful arguments in favour of a Supreme Court, rather than law lords, was transparency. The man in the street had no idea who the law lords were. The man in the street couldn't very easily get to see them in action because you had to go and get a pass and go and find a committee room in the House of Lords. It was not easily done, and nobody ever did it. And if you saw judgment being delivered on the floor of the House, it was wholly unintelligible, even sometimes to those taking part in the process. So it seemed to me that it was highly desirable that this change should enable the general public to see what the Supreme Court did, who the members of the Supreme Court were, and to be able to have access to the working of the Supreme Court. And all of that has happened. There was a lady who came to make a film before we moved from the House of Lords to the Supreme Court, over 2 years. And then there was another film made by, I think, the BBC with a team. And there was discussion among the law lords who became members of the Supreme Court as to whether we should cooperate or not. There was certainly one member who was very much opposed to being filmed at all. I had to take him out to dinner to persuade him to allow to be shown bits of the film that he had actually taken part in. But I thought it was a very good idea that this film should be made, and some of us cooperated to the extent of allowing the cameras to come and film us, going about our daily lives. Lord Hope was filmed pushing a trolley around the supermarket. I was filmed cycling up Hampstead Hill to have my morning swim, and actually I think having the swim.
Hopefully not in a transparent bathing suit.
No, not quite. And another member of the House was shown taking his wife breakfast on a tray. Now, that, I hope, was bringing across to the general public who saw these films that we were ordinary people living ordinary lives. And I thought that that was quite important. I and Lord Hope took the decision to allow television cameras into the court. They hadn't been in any court in this country before. We thought that was a good idea. By and large, we used to consult our colleagues before taking a decision like that. On this occasion, we didn't, because we were slightly apprehensive that we wouldn't get a majority. However,
like
after we'd done so, I think everyone thought we'd taken the right decision. And I think it's a very good feature of the Supreme Court that if you want to, you can see it in action as it's sitting, or you can go and review it by looking at a historic sitting.
Thank you, Lord Phillips. That last chance for anybody to interject here before I move to the next topic. I imagined you would.
I was very struck by that answer. I very much agree with the importance of transparency. I'm also always struck by, I open the Daily Mail regularly and read stuff about me that is absolutely libelous in every single respect. And I think to myself, oh well, nobody's going to believe anything about that, about me, like that. I then turn over another page and then read something about somebody else and think, God, they sound absolutely awful. I think to myself. Now, Lord Phillips gave the Daily Mail's account of the start of the Supreme Court, believing it all to be true in every single respect. As Lord Phillips knows, we produced a most elegant green and white paper in relation to it, which did focus very strongly on the importance of transparency. And because of the things that Lord Phillips did, Lord Hope did, Baroness Hale did, and other members of the Supreme Court, it is, for all the reasons that he has said, a vastly more open place where justice is done than the House of Lords ever was. And whatever else you think about the Brexit decision, there's a physical place where justice is done. Everybody knew what was happening, and the decision or the argument in the case was available to everybody and shown on the news on a regular basis. And so it's marked a very, very significant change. Yes. And despite Lord Phillips's craven belief of what the Daily Mail said, that was one of the reasons for doing it.
Indeed. Dominic Green, last point on this before we have to move on to Brexit.
I was going to eat a little bit of humble pie because at the time that the decision was made to set up the Supreme Court, I, along with other members of my party, argued that we couldn't see the point. It was going to, bear in mind that in terms of public cost, I think the cost of running the old House of Lords was about 250,000 quid a year, and the cost of moving it into the Supreme Court was around about 100 million, as I seem to remember, and the running costs...
The Supreme Court justice had very high standards.
They had very high standards, and the running costs of running this institution was about 13 or 14 million, and I don't know what it is now, but that was what it was going to be. This is back in at the time the move took place. And so we, being in opposition, said this is pointless, it's going to do the same role as the House of Lords, and we should leave it where it is. Now, we had a point But I do accept that it has been, I think, wonderfully transformative. I can't escape the fact that in the old days, if I wanted a judgment of the House of Lords, as a member of Parliament, you had to go up a funny winding staircase in the Victoria Tower and flash your members' pass, and a person behind a counter who'd eye you rather suspiciously would then hand you the judgment. The paper judgment would be handed down so you could read it. Other people had to pay a fiver, as I seem to remember, in order to get it. I mean, the whole thing was about as hidden away as it was possible to be. And I can't escape the fact that the magic of what's happened is that it has actually preserved some of the informality of the House of Lords, in the sense that the way the court sits. But it is accessible, and people are aware of what it's doing. And the old House of Lords didn't do that. It did it perhaps for lawyers, but it didn't do it for the wider public. And from that point of view, in terms of upholding the rule of law, I think it's been a very desirable change. And the other change which I did accept at the time was that there was some real value in the... we had to come to a point where the House members of the Supreme Court, or the House of Lords, were no longer sitting in the chamber, although I do regret that we still haven't quite sorted out the issue about the status on retirement. In my view, everybody who's currently in the Supreme Court should be going to the House.
We're coming to that as well, on the last segment of today, the last topic. But on the issue of regret, Dominic Reed, it's a perfect segue to the next topic, and that is Brexit. Because many people voted a certain way and others voted another way, and we're now going to explore whether they regret their vote. The government would never consider leaving other important decisions, such as whether military action should be taken against a foreign state, in the hands of the people. So was it correct, to the panel's mind, was it correct to put such an important constitutional issue to the popular vote? And I'll start with Natalie.
Well, I'm afraid I'm going to rely on Joe and Lai at this stage. You know, was the French Revolution a good idea? It's too early to tell. In the short term, I very much doubt that David Cameron would have any doubt about his answer to that question. In the long term, we don't know. I'm not sure that referendum are the best way to make intensely complicated economic and political decisions. And I'm certainly not sure that the way the referendum debate was proceeded was one that helped people make the most sensible decision. But I don't feel qualified to say any more than that. I think it's a political question.
We'll come to the politician on the panel, Lord Phillips. Constitutionally, was it the right thing to do?
Well, to have a referendum
on such an important issue, which we wouldn't call on military intervention.
I don't think it was a constitutional issue as to whether to have a referendum, because it wasn't a binding referendum. I think it was a very bad idea myself. I think that the issue was so complex and so difficult to get one's mind around all its implications, that it was something that was really essentially for government and not for the people. And I personally greatly regret the result, and I think we're beginning to see just how disastrous it's likely to be.
Lord Clark.
Well, I was party to the Brexit decision, and
speak as freely as you like on that topic.
And I'm not supposed to say anything about the Brexit decision. Nor am I going to make any political observations, so I'm not going to tell you how I voted.
Right. Lord Faulkner.
I think that the decision to have the referendum on whether we stayed in the European Union was terrible. I thought it was a cowardly, internal Conservative Party-driven thing to have done. I agree completely with Lord Phillips that it was a wholly inappropriate issue to have a referendum on, because in effect it was saying change the whole way that we do both large parts of our foreign policy and significant parts of our domestic policy. It was something that, as it were, infected a whole range of things, and it was something that should much more properly have been left to the political parties in general elections. If there was a mood to leave the European Union, that could have been dealt with by a political party arising that said they would try to leave the European Union. And UKIP was taking its chance in that respect, and that was the way to deal with it. if you start to take issues of that sort on a purely short-term campaign populist basis, you can do damage to the country. But we've ended up in a situation where Parliament agreed that the referendum should decide the issue, although I think it was a craven and mistaken decision to do it, having told the public, the politicians did, that they would decide whether we stayed in the European Union or not, and they, the public, having voted to leave the European Union, we are obliged now to leave the European Union. I don't think the point that it's advisory rather than binding makes any difference. If you had said, this will be the decision and we will abide by it, which is what the politicians did say, nobody was saying, well, this is just an advisory referendum, we'll take into account what you say, but we may come to a different conclusion. I think there is no prospect of departing from that. It might be that the public might change its mind in years to come, but I think we've got to go through with the consequences of what we, the politicians, said, which was, you decide, the public have now decided, we've got to, I'm afraid, go through with it.
Well, the public is changing its mind. The public, in fact, 2/3 of them now support Brexit because we have this new phenomenon of re-leavers. That is those of the 48% who voted to remain. Around 23 or so % of those have changed their minds after Brexit because they are fed up and want to get on with the job. So now roughly 2/3 of the country supports a Brexit due to the fact we find ourselves in this situation. We don't know how they would have voted if another referendum, or how they would vote if another referendum were to be held on the final deal, but that's where public opinion stands at the moment. Mr. Grieve. The calling of the referendum, was it not, wait for the question,
We've all read the Daily Mail.
holding the country, was it not holding the country hostage to what was essentially an internal Conservative Party crisis?
No, actually, I don't think it was. I think it was a rather wider crisis than that. Firstly, my views on the remaining and leaving are pretty well known. I supported Remain, and I believe that we made the wrong decision, and I think that the consequences of that decision, as time goes on, will become clearer as to some of the challenges and risks which that raises, although I don't wish to be a prophet of doom, and we may get ourselves through it. It's impossible to know how it will exactly unfold, but I haven't seen anything that's happened since.
What's the wider crisis
to make me change my view that we have made a decision which I think is mistaken. But I'm totally supportive of the Prime Minister, for the reasons which Charles has given, in trying to achieve the best Brexit we can, because it may have been an advisory referendum, but the fact is it was in practice binding on Parliament. Now, going back to its origins, which is where your question came in, I think it was a bit more than an internal Conservative Party split. It is true that my party has had a split on this issue for a long time, with historically a minority wishing us to leave and the majority remaining. But actually, what comes across to me from my 20 years' experience in politics is how this issue has festered, and probably been allowed to fester, by what I would describe in broad terms as the political class, who have always been willing to duck protecting or arguing about the merits of EU membership in favour of tending to blame it, sometimes correctly, for most things that they found they didn't like or the public didn't like. So that, quite frankly, by the time we came to the last 3 or 4 years, we had achieved a very considerable head of steam that extended way beyond the Conservative Party, of a public who were dissatisfied with our EU membership. Now, David Cameron, in holding the referendum, wanted, I think in his expression, to lance the boil. He wanted to try to bring this out into an open debate and resolve it. In that, particularly in view of the fact that he wanted us to remain, he made a political miscalculation, because the public expressed their dissatisfaction on a cross-party basis. Fascinated me how the cross-party basis actually worked out in practice. And even Liberal Democrats voted to leave, bizarrely, some of them. I know this may sound odd, but that is what I found in my own constituency. So, and I realised that the writing was on the wall about halfway through the campaign when I saw the sorts of people who were going to vote for Brexit. So, ultimately, this was a revolt by a large chunk of the electorate against the wishes of their own political parties. And it precipitated it. But then the question we do have to ask is this: suppose we hadn't done it, where would we have gone in terms of this issue festering? Well, had it been correctly addressed by the politicians, perhaps the festering would have stopped. It would have, the boil would have stopped festering. But actually, I think it's a much more profound and revolutionary phenomenon. What happened last June was a revolution. Now, I agree with Charlie that I think many of the people who voted for the revolution may not have fully appreciated that they were being revolutionary. I think they thought they were being traditional. And rather ironically, having voted for the revolution, they then handed it to a Conservative Party with a small c to implement the revolution, which is even odder. But the fact is, that's what they were being, and it was a very profound shift in public opinion. And the fact that, as has just been pointed out, you pointed out, now, 9 months later, 2/3 of the electorate appear to have rallied round the position that this is what makes them comfortable, is, I think, a reflection of the extent to which they were profoundly uncomfortable with the status quo that the EU offered, and a failure of politicians collectively to explain why it might be better than what they were going to vote for. So I'm afraid I think it goes rather beyond an internal Conservative Party split. I think it's one of the more profound shifts in British politics and public attitudes, certainly in my lifetime, and perhaps for much longer. It's probably the most profound revolution that we've had since 1689.
Moving on to there's a legal technical question I'd like to ask, which, Lord Clerk, forgive me, you may not be able to address because it is related to the Miller case. But in its judgment in the Miller case, the Supreme Court proceeded on the basis that once notification was given, pursuant to Article 50, that it was irreversible. So the Supreme Court proceeded on the basis that the Article 50 notification, once given, would be irreversible. However, it did not express a view on the matter. Do panel members have a view on this matter? And as I say, Lord Clerk, feel free to speak as freely as you like, though we will understand if you don't wish to address this particular question.
Well, I think the current position is that that is a question which is open to argument in the future. And who knows, I might be sitting in the case in which it argued it, so I don't think I will express it.
Indeed, thank you.
But I don't think it's closed. Indeed, it plainly isn't closed.
Right, following that gem of wisdom there, and in anticipation as to what happens next, Lord Phillips, do you have anything to say?
I think it is an open question, and it's not a question that the Supreme Court purported to resolve. The courts decide issues that are put before them, and it was common ground for the purposes of argument that it was irreversible, and so the Supreme Court proceeded on that basis. Now, I think technically it would be for the Luxembourg court to decide if the issue ever arose as to whether, as a matter of law, we could change our mind. And it's a nicely balanced question, but I think realistically, this question would never get to the Luxembourg court, because if we wanted to change our mind, I think it would really be a political clash that would then occur, and the question really would be, are all the other members of the EU prepared to let us do so or not? And if they were absolutely adamant that we're not taking these buggers back, there'd be nothing we could do about it.
Lord Falkland.
I very much agree with what Nicholas Phillips has said. I mean, it's not resolved by the Supreme Court. The man who claims to have written Article 50, Lord Kerr, says, I'm the draftsman and I can tell you it was intended that you could withdraw the notice once you've given it. But then we all know as law students, whatever the person who wrote it says it means, you've got to try and construe it on the basis of its wording. But I understand that there are quite good international law arguments that say it might be possible to withdraw the notice. But I think the key point is Nicholas's point, which is whether or not one can withdraw the notice depends entirely on whether or not one can reach an agreement with our 27 EU partners. The current position, as I understand it, is that our 27 EU partners are saying, by all means, withdraw the notice if you want. If you want to stop this process, you can. is what they are saying, because they hardly believe that we will. And if that is the political will of the 27 members of the European Union, then they are obviously not going to be stopped in giving effect to that by whatever Article 50 means. So I think the key question is exactly the one that Nicholas has identified.
Natalie, there's this question, but also I'm going to broaden it out as well and discuss a bit about the Great Repeal Bill, which is being suggested as the piece of legislation which will effectively kick in to replace all EU legislation in domestic UK law. Do you think that and feel free to address the last question as well, but do you think that this is a workable, practical mechanism through which for us to Brexit? The Great Repeal Bill.
I think it's an unbelievably complicated and difficult mechanism. I wouldn't go so far as to say unworkable, because ultimately if the bill and it's enacted, the courts will have to make it work. I think, interestingly, what it will give is a shift of power to the courts, because ultimately the courts will now have to untangle vast areas of law that were previously sent to Luxembourg and could be deferred to. Everybody can pick out their own tiny areas where you just think, how is this actually going to work? So I've been representing Client Earth in its air quality challenge over the last year or so. And I have very little doubt that the government's aspiration on air quality is to change the directive so that actually it doesn't have to comply with all the court orders that we've been getting over the last number of years. But how are they actually going to pick through the vast quantity of European legislation and pick out the bits they like and don't like? And is that an exercise they're going to do, or are they simply going to try and do the lot in one go? And doing the lot in one go, absent the other members of the EU, is in itself not at all a straightforward exercise. And to be frank with you, I don't think the civil servants or the lawyers in government have a clue I don't think they know what they're trying to achieve, let alone their ability to achieve it. But will it be workable? Well, it will give the courts and lawyers lots of work, and they will ultimately have to make it work.
Dominic, you can feel free to address any two of the two facets of that question.
Well, on Article 50, my personal view is I think there are good arguments that it is revocable, but it is ultimately a political question, and this should make quite clear I don't see any current prospect of it being revoked. So it would need a sea change. If there were a sea change, my feeling politically is that our European partners, unless we hugely antagonise them in the course of the negotiations, would be likely for a variety of reasons to want to keep us in the EU. So I think it would be capable of being revoked. But as I say, I think it's a very hypothetical question, because the Prime Minister is intent on taking us out of the EU, and that is what public opinion is currently demanding. So unless there's an extraordinary sea change, we will be leaving the EU, and there's no question of revoking it. As for the Great Repeal Bill, it worries me very much that we are taking on an enormous task. I agree with Natalie about that, and I don't know if the government wants to, in the process, to remove some of the European law that goes with it. Actually, the government's made clear that in the first instance, it's all going to be incorporated into our own law, and then at a much more leisurely pace thereafter, it is going to be replaced. Although, if we're staying in close connection, which is what the Prime Minister wants with our EU partners, the reality, I think, is that if we achieve a deal, the chances are that many aspects of our law are going to continue to mirror very closely the EU law which exists within areas of EU competence. Whether the public want that, I don't know. That's going to be one of the interesting issues as to whether there is public pressure for change by public opinion in certain areas. And the final thing, which I think looking ahead is of interest to me, but I'm not quite sure what the answer is that we are, of course, going to be making our own Supreme Court the supreme arbiter on a vast area of law where currently, for political reasons, we've said, well, it ends up in the Court of Justice of the European Union. We all then get really worked up about it because we don't like the decisions, but that's the political framework in which we operate. One of the big criticisms which runs around nowadays is that the Supreme Court our judiciary are too interventionist. But they're interventionist because Parliament, in its wisdom, has given to the judges the discretion of interpreting vast areas of law. And one of the ironies is we're about to give our own judiciary the final say in a huge new area of law, which is likely to attract, it seems to me, exactly the same criticisms. And I do worry about that, because I worry for the judges. We were talking earlier about judicial independence. I mean, I think politicians are going to have to be very clear, even more clear, about supporting judicial independence and discretion if we are on the point of handing to our own Supreme Court the final say in vast areas which are quite controversial, which they are at the moment. So not just applying a law to which the United Kingdom has said it signs up internationally and therefore has to be applied by direct effect, but one which ultimately Parliament has control over. So I do think that over the next few years we're going to see a potential revolution and debate politically about what is the extent of judicial discretion that we wish to have in future. And the problem is, as some of you will know, is that some of my colleagues in Parliament, not necessarily on the Conservative benches, argue that there should be less judicial discretion, but that means simplifying the law, or Parliament legislating more precisely so as to remove areas of judicial discretion. And the reality is that our society is so complex nowadays, and the regulatory mechanisms are so infinitely detailed, that actually we can't do without this role of the judiciary if we're going to function correctly. So I do happen to think this is going to be, if this proceeds as what I think it's going to be an area of debate which it's going to be impossible to avoid, and I'm not very sure how that's going to work out in practice.
Could I just have one footnote to that? It is rather striking, I must say, that we haven't yet seen a draft of the bill. We've heard a lot of it, but it would be quite interesting to see what the bill actually says, and indeed how it deals with these very questions. It seems to me one of the questions we're going to have to consider, or the government of the UK is going to have to consider, is just what the role of the CJE, or indeed the Strasbourg Court, is going to have in the future. In Strasbourg, we have a sort of rather wishy-washy provision that says the court shall have regard to decisions of the European Court of Human Rights. Now, what are they going to put in the bill in relation to the European Court in Luxembourg? They can hardly, I think, put in a provision which says the court shall have no regard to decisions of the court in Luxembourg. That would be little short of absurd, since, for the most part, the actual materials, statutory materials, would be the same, especially to begin with. So they'll have to have some very similar provision to the Strasbourg provision, namely that the English court shall have regard to decisions of the European Court. And then that will be better off or worse off.
Well, this brings me to the next question, actually, and that is that the Prime Minister has said that no deal is better than a bad deal. So is a future without any framework of EU-connected regulations a reality which the legal community must brace itself for? Lord Faulkner, looking at me intently.
No deal is so utterly, completely, irredeemably and totally disastrous for the country that the idea that no deal is better than a bad deal is absolutely catastrophic if that's what the Conservative government thinks. Imagine if you have, for example, no deal, there will then be, for example, 10 or 11% put on cars being sold into the European Union by the United Kingdom. The consequence of that will be that Nissan, which have been given assurances as to what they will stay in their factory in Sunderland, will immediately leave Sunderland and go somewhere else, and you will have the destruction of 2 or 3 significant communities in the northeast of England. But the disastrous situation having been reached that we're going to double down, we're going to have no deal, as Mrs. May says, then means, according to what she said in her Lancaster House speech, that we'll then go for this low rent low tax, presumably poor public service, Cayman Islands by Europe type country, because that is what she said she would do if we got no deal. So it wouldn't just be that we'd have a much harder time in selling our goods. We'd also change the very nature of our country and the way that we made money. So I think the idea of no deal is better than a bad deal is utter rubbish. I hope that she's only said that as a negotiating position, that she's saying that to the Europeans to make them believe, this may be in the national interest, that they can't just sick bad terms upon us. But the obvious nonsense of what she's saying, no deal is better than a bad deal, is really worrying.
Natalie.
I find this really hard. I think I completely agree with Charlie. No deal is inconceivable. I mean, think of what it would mean in the city. But I equally find it incredibly hard to see how either side can make a deal when they've put themselves in such a hard democratic place. So neither Theresa May nor Mr Macron give themselves much scope for a deal, even though both of them, I'm sure, know, and Mrs Merkel, that they have to reach a deal. And if you were an outsider living in New Zealand, it would be an utterly fascinating process. As somebody with children living in London, it's totally terrifying. Totally terrifying, because I do not see how Mrs Merkel can sell the Poles down the road and do a deal that removes their freedom of movement rights. And I equally don't see how Mrs May can allow the Poles to keep freedom of movement rights. So I am baffled, horrified and terrified.
Lord Phillips.
I think I'm in exactly the same position. I entirely agree with Charlie that the prospect of having no deal is horrifying, but it's not a prospect that I think is all that unrealistic. The actual cobbling together of the deal is not going to be at all easy. And so I'm very apprehensive as well.
Dominic.
I get people writing to me in my constituency saying, will you please sign in blood here that you believe that no deal is better than a bad deal? I get quite a few of those. And I reply and say, I find that very difficult because, from my point of view, I don't know what is a bad deal. I mean, discuss. What I do think I can say, and here I may differ slightly from Charlie, but logically, I don't think I can say that a bad deal must always be better than no deal, because I think that is illogical as well. I happen to think it's in everyone's interest to... It may be a lawyerly point, Charlie, actually.
But you are a lawyer, after all.
A lawyer.
Yeah, that's fair enough.
It's a fair point to make.
Yeah.
It's in everybody's interest to have a deal. I think I'm a little less pessimistic about the prospects of getting a deal. I think that there is mutual self-interest in achieving it. And so despite the pitfalls, the difficulties, I think that we will probably get to something. Whether that is a deal that people in this country want, or whether it meets the aspirations that the Prime Minister set out in her Lancaster House speech, which if you're able to achieve them, I think we'll be putting up statues to her in most of market towns, because it would be a remarkable achievement. She set a perfectly sensible aim, but whether it is one that can actually be delivered, I don't know. I have to say, in the long-term interest of the EU and ourselves, the closer the relationship we are able to maintain, I think the better it will be, ultimately, economically, and for all sorts of other reasons for both sides. But unfortunately, there are all sorts of other political considerations which may well intrude, which may make that difficult. So all I can say is I hope for the best deal possible.
Can I just say, I agree with Dominic in this respect. I think, looking at what they have published, the European Union, a deal is plainly possible. They're willing, for example, to be cooperative in relation to the border between Northern Ireland and the south of Ireland. They're willing to be in the same place as us in relation to European Union nationals here and in the UK. They're willing to do, as they describe it, a bold tariff-free trade deal with us. They're willing, if we can do a deal on the amount of money we've got to pay, to talk about these arrangements quite quickly. So it's there to play for. My genuine worry is that pouring scorn on the European Union from the United Kingdom, particularly in the heightened atmosphere of a general election, is going to make it very, very difficult to get a deal. So I think, I agree with Dominic, a deal is doable. The more you start shouting at them, like, for example, suggesting that the European Union politicians and officials were, quote, interfering in the UK election, which is what Mrs May said just before the local elections, in order to get a good result in the local elections, is not a sensible way to behave, and it'll make it harder to get a deal.
Lord Clark, do you agree with Dominic?
Yes.
Wonderful answer. We are moving on to the topic of diversity. Thank you, Lord Clark. We're moving on to the topic of diversity. We're coming to you on that topic. Hope you have an answer ready on the retirement age.
Is it on what topic?
Retirement from the Supreme Court. We'll come to you shortly. Yes, we will come to you. There has been much commentary in the media of the need for diversity within the judiciary and Supreme Court. Andrea Kuma of Justice has said that now is the perfect time for change, as the majority of the Supreme Court will be replaced over the next 3 years. Justice has proposed that there be targets with teeth for every court lacking gender and ethnic diversity. Apparently, we are performing worse than Armenia and Azerbaijan, or equal to them at least, in terms of diversity in our judiciary. Natalie, my question to you: is there a danger that with the pro-diversity agenda, that the messenger has become more important than the message?
No, I don't think so. I think it's very easy to caricature diversity as well. It's just about quotas and appointing lots of women, and everything else gets thrown out of the window. I think there was what the report points out is 3 really big reasons for diversity, and not just in the Supreme Court and the Court of Appeal, but also the one that I'm particularly passionate about, dreadful word, ethnic diversity in the judiciary and the Crown Court. I mean, the United Kingdom is disgraceful in the minute number of non-white judges in the Crown Court, and it particularly stands out because, of course, of the high number of ethnic diversity defendants in the Crown Court. And so the first thing is legitimacy. I mean, we're talking this evening about how important the courts are going to be in the light of Brexit and the attacks on the rule of law. And even my most apolitical, non-diversity conscious friends went, do you know, I was watching the news, Natalie, with the Brexit Supreme Court. Didn't seem to be a lot of women, an awful lot of white people. It matters to the degree, not in terms of having every group represented in the judiciary, but having a judiciary, a senior judiciary, that vaguely looks representative of the society it judges on. So I think there is a real legitimacy issue. But there is also a quality of decision-making issue. I simply don't understand statistically how we can think we get the best judges when we, one, draw them out at the senior level of a tiny pool of senior barristers who are themselves massively non-diverse, because women generally fall out of the bar. The women who manage to survive to the senior echelons are few and far between, even now, and even more massively privately educated, and not very ethnically diverse, although the senior bar is a bit better on that. So we're drawing it from a tiny pool. So how do we think we can possibly be getting the best people? Are all those solicitors really so stupid they couldn't get to the bar and therefore don't have the merit to be senior judges? I don't think so. But also the third thing is there is a real benefit, and there's masses of evidence of this, of getting a wider range of experience of the people who give the judgments. And not just in the obvious areas like family law, childcare, but right across the board, a diversity of thought, which comes from a diversity of experience, leads to better decision making. And that's accepted now in every field except the senior judiciary. If you have the vast predominance of people making the decisions being from effectively a very narrow group, white, male, privately educated, then there's a groupthink, and groupthink is not a great idea. So I think a more diverse judiciary would have a whole range of real advantages, but there's a long way to go.
Thank you, Natalie. When I was first asked to moderate this panel, I wondered if I was here because I'm looking at the diversity checkboxes, if I'm state school educated, comprehensive school, or if I'm from Essex, or indeed my Pakistani descent, or indeed my Muslim background. Turns out I'm the token media representative. Now, Lord Faulkner, is Liz Truss a living example that diversity does not always bring the best result?
The answer to that is yes. But can I say I agree strongly with what Natalie has said. And I think, yes, it's really important that the judiciary appear to be more diverse for confidence reasons, but much, much more significantly, the judiciary should be diverse, because if the group is reflective properly of the country that it is judging, then it is much, much more likely to give decisions that resonate as being correct. And if you had a group that was, for example, 93% state educated and 7% privately educated, which is the statistics in the country, and that was the judicial group, that would almost certainly have a different outlook in relation to a whole range of issues, how the law develops, because the judges have to make decisions about how the law develops, how you make decisions that might be described as discretionary, for example, in relation to what sentences to pass, for example, what is your approach to childcare issues, what is your approach in relation to personal injuries, damages, what is your approach in relation to commercial contracts. All of these things would be affected if you had a more diverse group, because the group affects each other. We are a country that is, as Natalie's report points out, the least diverse judiciary in Europe, with the exception of Azerbaijan and Armenia. And we will suffer as a country in the quality of our judiciary and the respect in which it is held, both here and internationally, if we do not urgently do something about it. And the one thing I'm absolutely clear about is the problem is not a lack of talented people who are from the groups that are not represented. It is because and I can understand this, what the judges want is people who deliver what judges want in a mechanistic way in court. The people who are best delivering what they want is barristers, because they know what judges want. That is an incredibly short-term way of looking at who would make the best judges. And when you then look and see when judges have been appointed from outside the normal places, they've almost invariably, not always, but almost invariably turned out to be successful as judges. So it is an issue that urgently needs to be addressed. And the three people who can make the most difference in relation to this issue are the Lord Chancellor, being demanding about change, the Lord Chief Justice, and the President of the Supreme Court. If they joined together and made it clear that our judiciary is at risk because of its lack of diversity, that would have a galvanizing effect.
Thank you. We do have to conclude soon, so I will ask you to keep your answers brief. Lord Phillips, is true diversity even possible?
I agree with what's been said about the desirability of a much more diverse judiciary. I agree entirely. The problem is how you get there. And how you get there, I believe, is by enlarging the pool. The problem is that a lot of things that judges do at the lower level involve quite complicated procedures, which, unless you have been in the business, you don't understand or are not in a position to apply. And so if you're going to draw from people who haven't got experience of the court process, then you've got to have a different educational system. You've got to be able to train them much more than the training that's available at the moment. We've always, in our country, proceeded on the basis that the judge is a second career that you base on the first career. But I think maybe that we've got to reconsider that so that we can draw in to the judiciary people who are not in the first career at all.
Thank you. Now, I know Lord Clark and Dominic, you may well have something to say on diversity, but I have separate questions for you as the last two questions. First, Dominic, and then we'll move to you, Lord Clark, on the issue of the retirement age of the Supreme Court justices, and we'll conclude with that. But Dominic, on the issue of access to justice, which is related, of course, to diversity, equality, and opportunity. There have been increases, significant increases in issuing fees for civil cases. Fees for employment tribunals have gone up. The erosion of legal aid, including legal aid for early advice in family and housing cases, has affected access to justice. The Law Society, in its election manifesto for Britain, calls on the next government to review the legal aid means test, to restore its real value, and to remove the capital test for those on income benefits. What do you say?
All those things are very desirable. The problem is going to be where we've been now for 10 or 15 years. It goes back a long way, as to the affordability of access to justice and the value that we as a society put on it. Now, as a lawyer, you won't be surprised that on the whole I argue in the general terms of my colleagues on the importance of access to justice. But even before the current coalition government came into office, we had been through periods in which, by various means, the idea that was promoted when legal aid first came into being has been diluted and changed by successive governments, including Labour governments as well as Conservatives. Part of the reason being that they saw the bill going up, and unlike the NHS, where they've been prepared to see the bill go up, in the case of access to justice, for reasons which I suppose have to do that fewer people think they're going to need to have access to justice, it's been a less popular theme. Do we have a major problem in this area? We do. How do we best address it? Well, that's quite complicated, but I suspect that I have to say this, that for all the respect I have for the Law Society's manifesto, I think that implementing it in practice is going to be, in the current period of financial constraint, rather difficult. As for fees, fees have gone up. Fees, of course, should not be taxation. I simply make that point. And, of course, one of the sets of fees that was put up, which is probate, a bit peripheral, but nevertheless relevant, it does seem to me that it may well not meet the criteria of a fee at all. And perhaps that's a good reason why we need to do a good rethink about some of these issues. But I would be misleading this audience if I thought there was an easy fix solution. Indeed, I note that historically, the manifestos of other political parties have tended to be quite muted on this subject. And I think one of the reasons is that politicians of all parties tend to say as little as possible about it, because it's rather intractable and they're not quite sure how it's best going to be addressed.
Thank you. Lord Clark. Lord Neuberger told the Lords Constitution Committee in March that judges should be allowed to sit until they are 75. Both he and you are being forced from the Supreme Court this year because of the mandatory retirement age. Lady Hale has said that it's a great shame that justices must retire at 70, as they are at the height of their powers. Are you getting, with all this that's going on with Brexit, are you getting out at the right time?
I don't know, I hope so.
You hope so. So the question I have for you is there an argument to go further and adopt the rule in the US Supreme Court which imposes no mandatory retirement age on serving justices?
I don't think I would.
And if not, what should it be?
Well, I think it should be 75. We've gone through quite a few different twists and turns over the years. Originally, like bishops, judges had no retirement age at all. And then anybody appointed after 1960, there was a retirement age generated in the High Court of 75. But you could go on sitting afterwards if they wanted you. And then they decided that wasn't entirely satisfactory because you get a lot of rather particularly doddery people who ought not really still to be going when they're 89. And so then they introduced a rule that said that it would remain at 75, it would be unlawful to sit after 75. But the first thing that then happened was that a case came along and the judge was sitting there for about 18 months. And the side that thought they were losing sent the judge a note which said, "We've observed that your lordship will be 75 a week on Wednesday. So a week on Thursday, I'm afraid you won't be allowed to sit." Because unfortunately they hadn't put any transitional provisions in place. And so he said, well, that's perfectly ridiculous. Parliament couldn't possibly have intended any such thing. And that was upheld in the Court of Appeal. But, but what then happened was that they did introduce some transitional provisions. And 75 worked pretty well for quite a long time. But then for some reason, in 1995, they reduced the retirement age for anybody appointed after the bill went through in 1995, so to 70. Now, I'm not quite sure why they did that, and I'm not sure that they had any very clear idea why they did that. There's a lot of problem because for quite some time, government said, well, we can't have 75 because we can't have 75-year-old magistrates, and you can't have a line between them. But now I think you can be 75 on the jury. And
Yes,
I'm not quite
yes,
sure
you can,
about
yes.
if you can be 75 on the jury, I don't see why you shouldn't be a magistrate or indeed a high court
Indeed.
judge.
And when are you due to stand down?
I'm stopping on the 30th of September this year. I could go on till May next year. And Lord Newberger, he's so young and bright and brilliant that he's one of these 70 people. So it's even worse in his case. He'll have to retire when he's 70, which would be at the end of this year. And so I think that they probably will soon replace it with 75, which I think would be a perfectly sensible thing to do for the future. And I think they'd probably come around to the idea that, well, I think I'd have 75 for everybody. And that I think would be a perfectly sensible and reasonably coherent system, which we don't really have at the moment. But maybe others in the room have some.
Indeed, and we're going to open it up now. We have about 3 minutes, not too long. We went slightly over with that, but we have one question at the front there. But what I'll ask you to do is raise your hands, mention your name and your affiliation and whom you're asking your question. And I'll take a few together, and we'll go one round quickly through this whip round, and then we'll call it a day because it is hot in here. So I'll pick you as we go through together. So there's a question here from Graham Wood. Yes.
This is a question perhaps for Lord Phillips and Lord Clark. It's a Brexit-related question. And in their Brexit report, the Commercial Bar Association strongly recommended that the Brexit negotiation should include an agreement for the continuing application of the Brussels bond recast regulation following Brexit, and recommended that the UK adopt a Denmark-style standalone agreement with the EU to ensure that regulation which governs jurisdiction and judgment continues. 2 questions about that. In your view, is it realistic to expect the European Union to agree to the continuation of that regulation when Denmark is an EU member state and we're not? And secondly, in your opinion, is it unthinkable that the common law should revert to govern jurisdiction and the enforcement of judgments post-Brexit in the relationship between the UK and EU member states? Because I think I'm right in saying that major states, such as the United States, Japan, China, Russia, there has never been a reciprocal enforcement or jurisdiction treaty. And everything seems to have worked relatively well.
So if you write those questions down, we'll come to you at the end and we'll go through these questions to whom they were directed. Thank you. Does anyone else have a question? Yes, there's a gentleman at the back there. If we can get the microphone to him, please. Okay, all right, shout.
Nick, that is a parent question to anybody who wants to answer it. Isn't there a real issue with such limited democratic oversight of the appointments of Supreme Court justices? I'm loath to suggest confirmation hearings for obvious reasons, but shouldn't Parliament have a greater role?
And your name was again, sorry?
Nick Bennett at Barrow.
Nick Bennett?
Yeah.
Right, any other questions? Yes, the lady at the end there. Are you able to shout or do you need the microphone?
Yeah, maybe. I'm Britannia of the Mayor.
Yes.
My question is in relation to the Brexit. Why hard Brexit?
Why hard Brexit?
You use
What's that question?
Why hard Brexit?
Why hard Brexit? Last opportunity for a question before we go back to the panel to end and conclude. Yes, sir. Your name and affiliation.
Richard Kirk, no affiliation. Is it not axiomatic that many of the problems we've been addressing and alluding to are probably derived from the claim that we're a democratic country, but we're clearly not, because of the absence of any form of proportional representation, and the cumulative effect of over at least 40 years of a toxic, poisonous campaign by the mass circulation newspapers against Europe.
Against Europe. So you have a fake news question and a question comparing us to North Korea. Right, sorry, I'm being facetious. Right, so we've got those questions, yes? Right, so I think that's going to be it for the audience questions. We'll go to the panel, a quick roundup. The first question was to Lord Clark and Lord Phillips, and then we'll open up the other two for the remaining three panels, and then we'll conclude. Lord Clark, would you like to begin?
Well, I think the recast Brussels regulation point is, I think, very important, but it's going to be very, very important, I think, for the European countries just as us, that we should have some jurisdiction arrangements so that it's quite clear where, if you have a dispute which has an Italian aspect and an English aspect and a German aspect, the Brussels regulations have worked pretty well under the European system. Instead of having the old-fashioned forum non-convenience, which was hopelessly wishy-washy, the Brussels regulation, and now the Brussels regulation recast, has actually provided a very, very good way forward. And I should be very surprised if, by some method or other, we don't sign up in the future to the Brussels regulation or something like it in common with the other members of the European Union. And I think that's true in a lot of other areas. So maybe if we came back in 10 years' time, it won't look so different after all.
Thank you. Lord Phillips.
I think I would agree with that. The question then is, if you were to get issues, who's going to resolve them? We haven't yet sorted this out. If we're going to have international agreements, one's got to have a dispute resolution mechanism, and that probably means a supranational court. And which is that court going to be? That, I think, is an enormous question to which no one's really suggested the answer yet.
Lord Faulkner, Dominic Grieve and Natalie Levin, the questions that remain, if I could encourage you to stick to those, is the question on our proportional representation and our lack of democracy, the media's role in Brexit, why hard Brexit, and the question from Nick, which I didn't quite catch, but I hope you caught the question.
Oversight of Supreme Court Justice.
Yes, that's the one. That's the one.
Shall I go first?
Go first.
First of all, I disagree with you that we don't have a real democracy. I believe that we do have a real democracy. I don't favour a changed proportional representation. I think the current system is the right system for two reasons. One, I think the link between the Member of Parliament and his constituency is really important. And secondly, I think we get the governments that we want. If you look back since 1945, so for example, in 1945, I think the public definitely wanted a big Labour majority. I think in the 80s they didn't want Labour, and I think the governments we got reflected that. So I'm against a change. In relation to your reference to the press being toxic, in very many respects, there are strong elements of the press that are toxic, but the price you pay for freedom of the press is you have lots and lots of members of the press saying things you don't like, but that's called freedom of the press. In relation to no oversight of Supreme Court justice, I'm strongly against any parliamentary oversight in relation to the appointment of Supreme Court judges or any judges. I think it is really important that the rule of law is kept separate from trying to suck up to MPs or parliamentarians. I've got no problem with judges giving evidence about how the justice system is going to parliamentary committees, but if you end up in a system like you've got in America, where you've got to be sound on this or sound on that before you can get approved, that would have a disastrous effect on our system, and you'd end up in a situation where, for example, when the question of who was going to be the President of the United States arose in 2000, every Supreme Court justice voted with the Parliament with a political party that had voted for them, and so the Republicans won on purely political grounds.
Thank you.
And I don't want to go anywhere near there.
Thank you. Dominic.
Well,
Let's keep it brief.
Very briefly, I agree with Charlie on oversight. I happen to think that I don't believe that there should be parliamentary oversight of the appointments process. I think it will politicise the judiciary, and I can't see the advantage of it. I also agree about PR, and I mean, I would only add, the purest piece of democracy we've had is the referendum, of which I detect from your question you are not very happy with the outcome. I simply point out that is in any way a piece of pure democracy on a binary question, in or out. Finally, why hard Brexit? Well, I think because there is, I'm afraid, a remorseless logic to hard Brexit, in that soft Brexit would imply an EEA relationship. And leaving aside the question about thereby not getting control of freedom of movement, is one of the issues. The reality is that it's rather odd to vote to leave an organisation and say that you believe that the world at large and the ability to fix your tariffs is the thing that you want, and then to settle for what at least arguably might appear logically to be a second best relationship rather than staying in. It's always been, I think, the difficulty. You can make a cogent argument, it might be in the national interest, to remain in the single market and the customs union. But if you're doing it, you then have to address the issue as well, why are we leaving at all? And so, as an issue of political dynamics, even though I have to say my personal view was this issue wasn't answered by the referendum, I certainly don't think that. I don't think the issue was posed. It was impossible to have a debate around this matter. I do think that there is a certain remorseless logic that it's a difficult position to defend. If you actually look at the position we're at the moment, is that the Prime Minister has announced she would like a relationship which is very similar to remaining in the single market. In fact, as good as she can possibly get without actually being in it. And that is the current position of where we are. And as I say, I'm not surprised that we've come to that point in view of the difficulties one has if you're then trying to argue that in fact the single market and the customs union are things that we ought to stay in, and yet we're arguing that we ought to leave the EU.
Thank you. Natalie.
The only one I wanted to comment on was this democratic oversight of judicial appointments. I wouldn't at all support the American system of hearings, but it is interesting that the countries that have managed to achieve a step change in diversity of senior judiciary have all done through the political process. That is ultimately, almost certainly, the only way to achieve a change at the highest level in anything like the short to medium term. And the way that our report balanced that was to have these targets with teeth and to have a parliamentary committee to which the Lord Chief and other senior members of the judiciary had to pitch up and explain why the targets hadn't been met and what steps they were going to take. So we felt that had involved some political oversight, but not directly in the appointments, which I think would politicise the judiciary and could have very unfortunate consequences.
These have been Lords Clark, Faulkner and Phillips, Queen's Counsels Dominic Grieve and Natalie Niven. I have been Majid Nawaz. You can catch conversations such as this, also and other such conversation on my weekend LBC show as well, if you care to tune in on Saturdays and Sundays from 12. We want to thank you all for your patience in this heat. It's been a fascinating conversation. I'd like to thank the panel members for this riveting and stimulating conversation, and thank Graham Wood of Europa Law, and the Stroke Association, in which this event is to support. So thank you all, and I'll hand over to Graham now, just to guide us all towards the reception. Thank you very much. Round of applause. Thank you.